5 seconds to go. Start. In this regard, the Learned Council has also referred to a decision of Bombay High Court in the case of Ajay Ram Pandit versus State of Maharashtra, 2022, SCC Online Bombay 3920. Stop para. Learned Counsel for the appellant has further submitted that although in the present case neither the public prosecutor nor the defense counsel raised the issue of mental capacity of the appellant, the trial court was under an obligation to ascertain his mental capacity, particularly in view of the prima facie evidence available before it. Stop. According to the Learned Counsel, it was the duty of the trial court to have made such an assessment, and for that purpose, conclusive evidence was not required and presence of some doubt itself was sufficient. Stop. The necessary inquiry having not been made, the trial stands vitiated and consequently, the benefit ought to be extended to the accused appellant. Stop. The Learned Counsel has also referred to the decision to submit that the act of the court should not harm a litigant. Stop. The Learned Counsel has even referred to a decision of the Supreme Court to submit that therein the accused was permitted to raise the defense of competence even though it was not as such raised by the counsel, and has submitted that the trial court ought to have ordered examination of the accused with regard to the propensity capacity. Stop para. Learned Counsel has extended his submissions to the effect that since the evidence of PW2 and PW3 gave rise to a doubt in relation to the mental capacity of the appellant, the trial court ought to have given an opportunity to the appellant to explain the circumstances of such abnormality at the time of his examination under section 313 CRPC, because these aspects had a bearing on his capacity and ultimately on his defense. Stop. The Learned Counsel also submitted with reference to an observation of this court in the case of Rahul versus State of Delhi, Ministry of Home Affairs and another, 2022, SCC Online SC 1532, that a judge is not expected to be a passive umpire but is supposed to actively participate in the trial, and to question the witnesses to reach to a correct conclusion. Stop. The Learned Counsel would submit that, in the present case, the witnesses examined to establish the guilt were not cross-examined on the relevant factors, particularly as regards mental capacity of the appellant, which ought to have been ensured by the trial court. Stop para. In the last limb of submissions, Learned Counsel for the appellant has submitted that even if it be taken that the evidence on record did not establish conclusively the mental incapacity of the appellant, it indeed raised a reasonable doubt as regards existence of all the ingredients of section 300 IPC, including mens rea, and hence, the appellant was entitled to be extended the benefit of doubt. Stop. The Learned Counsel would also submitted in the alternative that the conviction, if at all, ought to have been under section 304 IPC. Stop. In this regard, the Learned Counsel has referred to a decision of Calcutta High Court to submit that therein the mental state of the appellant, who was a habitual ganja smoker, was taken into consideration, and accordingly, capital sentence was converted to transportation for life to meet the ends of justice. Stop.